one thing we should have told you, both of these cases are real cases.
Yeah.
Yeah, we have changed all the details so that you guys would not be able to track them down anywhere, but they're real cases,
Yeah.
both of these. So we didn't do that for this one, particular one, but I could see the challenge. I'll discuss the challenges why we didn't go that route. We have gone that route for some other files, but not in this one.
In terms of the financial hardship, that is something that obviously they were subject to in the Azores, but the Azores is EU as well, and so that's hard to really put in as an argument, I guess, in terms of their inability to work elsewhere at the Azores, because they have that.
Mm-hmm. True. Anyone else? First thoughts that are coming.
Someone at this table mentioned that they initially came to visit family, so there would be family connections here. To explore.
Yeah.
And the child, I guess, must have come, if this was in 2015, and we're thinking 2019, maybe when she was 4 or 5. So that's all her schooling and possibly her language skills.
Are all here.
Here.
That's a really good point on her best interest of the child argument, that the child actually, for all practical purposes.
And that she also may have grandparents here, aunts and uncles, and
a whole community of support, yes, absolutely. That's exactly what the argument also is in the agency.
Just thinking back to talking about resiliency earlier, like this couple has definitely shown that, and like has lots of evidence behind the fact that they pulled themselves out of that situation of poverty in their home country and have not only like made their way to a new country, but have actually established themselves and become self-sufficient. So that's, I think, like, works in their favor.
Absolutely.
it's not quite stated, but does what's her common partner's name? David? Does David know?
Yeah, David knows. David knows, and the reason, just going back to why we didn't consider doing a work permit or anything like that, because David actually is supported by a union which works with non-status people legally, and they are going to, like, they're in the process of doing a work permit application for him.
Oh, okay.
So that means that if David gets, like, if successful that strategy, she will probably also get a spousal work permit. And therefore, when we were working with her, we only focused on the agency aspect of it.
Okay. And then he was her dependent for the purpose of the agency.
Yeah, that would be, yeah. We have the whole family included, because we don't know where that's going, right? Like, we don't know if, when will that happen, how soon. We know that he's working on paper with all the deductions. And there is a carpenters union in Toronto which has a history of doing this with a lot of they're very strong advocates, and they actually work with non-status folks who can get a special SIN number and work with them. So it's very rare that happens. I was actually surprised. This is the second time that I've come across with someone who is working in that trade, and that union is supporting them. They actually offer to pay for their agency as well. So it's like one of the rare of those situations.
I understand well that actually union is also involved in hiring openly a person without work permit.
Right?
Really, I learned something today that I never really
very strong,
suspected.
Very strong advocates.
They're actually breaching immigration law, and it's
not immigration law. Not immigration law. They're directly breaching law of the land.
I mean,
yeah.
But immigration law is law. It doesn't matter.
It's
how we call it, but. Aren't there penalties? Is it like?
Yeah, if they get investigated, I guess they have enough money to maybe not worry about that much.
Yeah.
For the penalty, and then that's another thing that we have to remember, that how many times do we actually see employers getting penalized for hiring people without status, or underpaying people, or not treating them well, or sexually assaulting them? Like, how do we really?
Yeah.
How many cases have you heard of someone, an employer getting?
So, and it wouldn't be a factor in agency application working without work permit. It wouldn't really be against.
I mean,
This factor wouldn't really be relevant at
It
all.
won't be relevant.
This fact that
No.
person worked.
Without a work permit? No, we use it like to show that they're not gonna be
Breach of-
inadmissible.
So there is no inadmissibility
No.
in that sense.
No, there's no misrepresentation. We'll talk about misrepresentation though.
Okay.
We'll talk about it in like,
Yeah.
that's why we want to do the case study so that we can get to the misrepresentation
Yeah, okay.
piece.
Would you consider a TRP in a situation like this?
I had a case similar to this scenario, but in the assault from the employer, but she had not been here long enough for me to have enough factors for like an agency application, not established enough. So she did make a complaint to the police, and we used that to get a TRP and work permit, and in hoping that she will have enough time to establish herself so we can put her in agency.
It wasn't that TRP, the human trafficking.
No.
No, it was
This
just
one
a
is
regular one.
just a TRP. The human trafficking TRP, how many, like we have a slide on that, how many of those have you seen?
It's only come up this year for us, and it was not even a kind of a, it was, we had talked to the client about it. There's that initial 180-day one when the story is still kind of coming out, that seemed like the best course forward because we didn't have all the information. It was ultimately something that she didn't want to pursue. But and if we don't have time today, maybe I could just talk to you guys, but I'd like to know more about that.
Yeah, so we have a slide on that and we do see those applications as well. And actually at one point for Maria, we did consider putting in human trafficking argument in her agency as well. As an alternative argument because of the fact that she was almost living in trafficked conditions where this person would pick her up, drop her off. Like she had all the constraint. So if you look at the definition of human trafficking, she could almost qualify. But again, because there were so many other things happening in her life, we decided not to go through with that. But we did consider, can we make a human trafficking case for Maria? Can we actually pursue that? Anything else that we are thinking we are not talking about in this particular case? So the police case is a good point. I think your table talked about that. If she makes a complaint, which she did, the perpetrator was actually multiple, like he was charged with multiple charges, not only Maria, there were other people involved who also came forward after Maria came forward. He has multiple charges. So Maria has actually made a complaint. She did go through with that. And what that did was that, yes, it does create that notion that she can stay here till the case is decided, but what we have been doing is we have been pursuing with every stage of that case. As it proceeds, we update immigration. So he was convicted on three counts. We have updated immigration on that. And she's still to go back to give more evidence, and we'll see what would happen with other stuff. So we are updating immigration of how it's proceeding. We don't have a clear guideline on whether they are informing her. They are like they as in cops are directly informing the immigration as well, because from our reading of it, there is no requirement for the cops to inform of a victim's situation. They are only required to inform IRCC about someone who is charged and is also non-status. So a non-status victim is not required to be reported by the cops to the IRCC. That's the reading. That's plain reading of their policy. What they're doing, we don't know. We haven't heard ever from IRCC directly. For a while, we were waiting to see what would happen. Like we were like, she has made her statement, the charges are laid, and we just waited it out. because we wanted to see if there was an action which will be taken by them before we proceed. Nothing happened, and we waited enough time so that we were sure that there was no movement, and that's when we submitted the file, because we didn't want to do anything to disturb the apple cart. What else do we want to talk about? We talked about the best interest of the child. The best interest of the child is actually not very strong in this case, because the child came here, the child is not Canadian born, but we have looked into what other relationships she has, what other people does she have, so we have relied on that. And we have also relied on a lot of evidence of what happened to her in Portugal. So her background information is pretty solidly given in there about her history, like the
child's history.
Yeah, the child's history, the mother's history, what was going on in their lives in Portugal has been submitted really strongly, because the whole thing about if she's removed back to Portugal, what her life would be like, including the fact that she's a survivor of sexual assault in Canada, and how her community will perceive that back home, and how she would be looked at, because she's not married to David. This is a common law relationship. So what is the impact of a common law relationship back home and as a survivor? We have talked a lot about that experience in the agency. So thinking about what is happening in that country for a woman of her, like the caricature of her experience, what would happen to her?
And so when you're framing that, because there are the Azores, and then there's Portugal, and then there's the EU, obviously it wouldn't be so easy for her to go to Sweden if she doesn't speak Swedish or things like that. But what about Portugal? What about Lisbon? I know it's not a flight alternative argument we're making.
That's actually covered in the agency. Her attempt to go to mainland Portugal and what her experience was there, and sort of setting up the hardship argument for what would happen if she returned. Also,
go ahead. So we looked at what kind of profession she was involved in, what was David doing, what was Maria doing before coming here, what was their life like in Portugal before coming to Canada, what their life became after they have come here, what is the possibility of their life here, and what would happen if they go back. So it's a very lengthy submission. We struggled with it. It actually sat in our office for almost 6 months. This file was sitting with the office for almost 6 months before we actually filed it, because one of the lawyers who it was assigned to first actually could not make sense of it. She was like, I don't think we can file any agency on this. There is not a possibility. Because it is tough. She's not from, say, a country where you can easily make an agency application for. She is not necessarily, a survivor of domestic violence or intimate partner violence. She has survived violence from her employer. So the whole thing we have talked about is the accountability of the Canadian system to protect people who will come and live here, and how the system has failed. Right? So the whole approach is what we were talking about yesterday evening, that she was working illegally with this person because she could not work legally. If she had an avenue to work legally, and she could not come forward. So as far as the police case goes, I think it's going in a very positive direction. And till we had a good sense from the Crown, like, are they going to press charges? Is it going to go forward? Are they actually going to take it seriously? We did not submit anything, because we, again, as I said, we really waited and watched what would happen to her criminal case. And once we knew that's proceeding, we are also supporting in her criminal trial. So that's another thing that we are doing. We actually have been assisting her through the criminal trial process and giving her support in that, because we have an independent legal advice for sexual assault survivors. So it's really a 360 kind of wraparound service that she's getting from us.
From a technical standpoint, because she was non-status, when you submitted the agency, we were talking about, well, if she, if he's charged and she has to stay here to testify, then she'll be allowed to stay. But if that concludes, like, what's her underlying status? did CBSA just not move forward with an exclusion order or anything like that?
Nothing.
They have no status.
She has no status.
But then what happened or what could happen in a case like that? I mean, she has no status, wasn't given a TRP or any sort of temporary, and then what would have happened, or maybe what did happen, if CBSA sees, well, this person's without status, it's filed an H&C, like, I mean, normally what happens here, and they're pretty on it here,
Yeah.
unfortunately, is exclusion order and then PRA.
Yeah.
And I don't know if that's...
I don't know if PRA would be offered to her. I'm not sure. And in Toronto, I don't think the officer would.
Well, here it would be exclusion order as soon as they see that you're, well, you know, notwithstanding this particular circumstance, but this is what, so when clients come with, we file an H&C without status, this means that Border Services will come issue an exclusion order for being non-status or lack status, and then give you the opportunity to apply for PRA, which is okay, but then you don't know if it's a year or 3 weeks, and then you've got this race with the H&C and the PRA, and hopefully we decide together.
So the only reason we did not, as I said, we did not think of doing a TRP in her particular case, which we do for other cases, is because we know that her spouse is working on something else, and we didn't want to have too many applications of a similar nature in the system for the family. So we focused more on H&C, but if the spouse was not on the scene, we would have gone ahead and applied for a TRP in this particular scenario. We would have pursued for that. We would have disclosed it to them at that point that the ground of the TRP is because there is a criminal case pending and stuff like that, which we have disclosed in the H&C now, but with completely different framing of it. We are not saying that she needs to get temporary protection. We are saying she needs a permanent protection of Canada because this happened here. And what we have done in addition, which is irrelevant for our conversation, but we have a criminal injuries compensation scheme in Ontario, which you have a very different compensation scheme which only comes through criminal system. As from what I understand, you have a victims fund and not a criminal injuries compensation the way we have it. But the finding of the compensation usually means that the board believes that the crime happened against her, which in this case they will give a finding for sure because criminal case has already confirmed that the crime happened against her. So it is going to be an automatic, but we are just to substantiate her H&C ground, we have also applied for the compensation. So that's an additional application that we have made. I don't think you will have an option of doing that here because I looked into your victims fund once and it's very different than ours. You have a very, you actually have it through your criminal system. You have it, but it's very different than ours. So, is there any other question for Maria? Can we move on?
Not specifically for Maria, but related.
Yeah.
Is TRP necessary if a person is involved? I mean, to keep someone in Canada, to remove her from risk of being deported or excluded, to be issued exclusion order. If a person is involved with a criminal case, either as a victim or in any way, because this person is required to stay in Canada while this criminal case trial is going on. So would Canadian Border Services insist on exclusion order or deportation while a person is engaged with the system? Yeah, which like either as a witness or as a needs to be present.
Yeah. In case of a perpetrator, I know that more and more in Toronto, they will, if he or she is accused of a crime, they will more and more impound their passports so that they don't leave. So they wouldn't necessarily issue an order for, like in Toronto at least I can tell you, there is not an immediate order issued by CBSA, but the courts will impound their passports and make sure that they don't have, there's no flight risk. And they will send all that information to the CBSA. So CBSA would be like literally ready on a standby to remove this person with all the arsenal in place once the decision comes out. So that's what happens if you're charged. If you are a witness, I have not seen a removal order for our witnesses so far, but I can't say that they don't issue removal orders. I'm pretty sure they do exclusion orders as well as they actually take them to the removal process. There was a media reported case recently where a woman was actually removed from the hospital she was in while she was supposed to be a witness in a case. And somehow no one actually advocated for her, and she didn't put that forward and saying that I need to be staying here. And it was some kind of a weird decision was made by the CBSA that, oh, you can actually send your written testimony if you're not really necessarily.
So it's always advisable to apply for TRP?
That's what we would say. That
if there's grounds for it, maybe.
yeah.
Like, for example, the last one we did, we were able to get the officer to give us a kind of a letter of support saying that this client is needed for the ongoing investigation and she's necessary, so we were able to include that with the TRP application. That was useful, and so in that case we said, yeah, we should go for it, but it depends on the facts.
Yeah, but I think if you can have a relationship with the Crown's office and talk to them, that's something which is really strongly advisable to do. Because they can give you a sense of, even if they're not the Crown on the file, but they are in that office, they sometimes can at least give you a guidance on what direction this file might be going, which can help you to make a decision on what you want to do with it. Because if they know that the charges won't be going forward, there is a deal which is going to be basically, the Crown is actually going to agree to some terms and something else is going to happen. So you should have a fair idea of what strategy you want to take. We have again, I don't know if you have a similar office, we have a Victims Witness Assistance Program called VVAP. I don't know if you have those in your criminal courts here, and those witness programs can help us as well. Do you have that?
No.
No? Okay.
No, something, but not really.
Not really, yeah. We are trying to be in criminal courts more and more. That's what we are trying to do, so that we have relationships there. Because we have very few relationships in criminal courts at this point, but we are trying to have, we're attached to a remand program right now, so we're trying to get a presence there so that we can have some relationships who can help us. Okay, so we will very quickly move. Okay, so we wanted to talk about the misrepresentation and inadmissibility piece because it came up as well, but we also thought it's an important to know about within the gender-based violence context. We all know that conditional permanent residence does not apply anymore, so that was gone almost 2.5 years back at this point. But in many cases when women leave a spousal or a common law relationship where there has been abuse, we see that their abusers will write a poison pen letter to CBSA saying that she came here just to be in Canada, she was never genuine about this marriage, and there will be a fraud investigation that will open against her. So it is a section 44.1 report that will be written against her. That negative report does not necessarily automatically take her to Immigration Division for an inadmissibility hearing. I have had cases where there is a negative report written by the officer, but the minister's representative decides not to take her to the inadmissibility. But I have also seen where the negative report was written and they decided to proceed. So we have a case in clinic where her 44.1 proceeded, and we chose, and the Minister's Council settled with us, and instead of filing an HNC, we chose to do a refugee claim in her case. So depending on where things are happening and what status she holds, you might be making a choice on what you want to do in her case. In most cases, you'll be making an HNC when someone is being investigated for misrep.
Was the decision to make the ref claim informed by the fact that she would be getting a departure order and couldn't make it afterwards?
She actually got a departure order. What happened in her particular case was her misrep was opened at the time she was landing. So they did not land her. She came as a sponsored person, but instead of landing, they actually issued a 44-1 and a departure order along with it. So her option was either to file an appeal against the departure order or comply with the 44-1. She complied with the 44-1. She got to the admissibility. The Minister's Council settled with us, but our client does not have any status. So in looking at the country she is coming from, we decided that we'll make a refugee claim over an agency because she has no agency grounds.
And in a case of poison pen letter like this, is there a procedural fairness letter first from CBSA?
No, if they open a 44-1, if they are opening, they'll open a 44-1 right away.
So it's at the admissibility hearing then?
Yeah, but your submission are almost like HNC application, where you're making submission for a client for in that 44-1 investigation. I use the same kind of format. I use same kind of submission. I use same kind of. So what it is basically a hybrid between your sponsorship appeal package, where you were talking about all the genuineness of the marriage. If you do sponsorship appeals, so take that and take your HNC format and basically marry the two. That's the submissions that you should be making. Giving them too much. In those cases, my strategy has been to give them as much as I can, because remember, the immigration division does not have an equitable jurisdiction. You will get super stuck when you get to ID. So what I do is I try to resolve it at the investigation stage, and I have had a very successful rate in most of those cases, because my strategy has been to make this officer see what has happened to my client right at the offset, and give them as much information as possible. Although I can tell you that a couple of times it has gone to the ID. Again, if you give them enough, they will settle with you. They settle routinely for the ID stuff, I feel, at least in our parts of the place. The second part is, which not a lot of people don't get upset about it. I personally get very upset about it. I don't know why, because maybe I have had a few clients who I feel have been unable to move on in life, because there is a 5-year ban on all the sponsored people to sponsor anyone else into the country. So which is a carpet ban. So 5-year ban and conditional permanent residency were introduced in IRPA at the same time. Conditional permanent residency was removed, but 5-year ban has not been removed. And I have this here just for us to kind of maybe think about it as advocates and lawyers, that this is one piece of legislation in IRPA that we can actually advocate for and get it removed, because it is also against basic human rights. I feel to have, say, you can't get married or you can't sponsor anyone. Even if you're married, that person cannot come to this country.
I'm just curious if you know if that's just family class sponsorship, or if that could also be refugee sponsorship as well. If the ban is just specific to family class.
It's very
or
specific.
all sponsorship.
No, specific to family class. It's very specific to family class. It's basically Jason Kenney's answer to that people are committing fraud.
That's his name.
Yeah, it was his answer to that, basically. That's what it is. Okay.
You send me that.
These are just some important considerations that you should be looking at when you're filing an application for your client. The law changes.
The forms changes.
Forms change all the time, constantly. Discretion's always at play, and remember, precariousness of status can be a root cause of coercion, and the client-centric approach of letting the client make their own decisions. These are some charts that we thought you could take a look at. These are just the federal, I guess, benefits, not benefits.
Yeah, services,
Yeah.
benefits.
Federal
Yeah.
services and benefits, you take out the provincial ones, that a refugee claimant would have access to. Open work permit, study permit, Canada Child Benefit, and they get the interim federal health program coverage. HNC applications can apply for an open work permit once they receive approval in principle. Same thing for study permit. Canada Child Benefit has to be in the 19th month of a valid permit. And healthcare, there's generally no options for healthcare for agency applications.
Till they get the first stage.
And even in
And even in
Nova Scotia.
Yeah.
After First Nation.
The Canada Child Benefit, there is a clinic at in Toronto area which is trying to bring a class action.
Is it your own clinic?
No, it's the Metrotronic Chinese clinic.
Oh, yeah.
I was working with a group of parents like 10, 12 years back who wanted to pursue something, but it never culminated. But I know that these guys are looking at a class action, so keep an eye on that.
So we already talked about that. Here we go. We're gonna no, we talked about this.
We're
Okay,
trying to
so-
see what we have not covered
Here we
yet.
go. So this is a little bit of information about what you can include in your packages, your agency applications to prove the abuse or violence and the consequences that it's had. So, any police or criminal court materials are useful to persuade the officers, family court materials, restraining orders, bail conditions, any custody documents, any child support agreements, separation agreements, and opinions from a family law lawyer about enforceability of a family court order abroad is helpful as well, because sometimes they'll come back and ask you, does this person have sole custody of the child? And especially if the other partner is not in the country with this woman and she's a single mother, that occurs. Okay, next.
Yeah, so support letters from professionals, I think we've kind of been talking about it all along. So counseling letters, psychological assessments, medical assessments, confirming any injuries. So recognize women's strength and resilience, I think we talked about it. Prognosis of made to leave Canada, address credibility or testimonial issues, show the basis of their findings, scope of expertise, should not make findings outside their expertise and role. So always try to see if you are getting someone to say something. As I said, the mandate piece is really important in every letter. Think about that, like just basically establishing that this person, when they're saying this, there is a purpose for them to say that. Also remember that you might not be able to track the same professional down after a few years when you're trying to do an update if this agency will stay in the system for very long. So always trying to kind of keep that at the back of your mind, because sometimes the files can take for so long and she might not remain in touch with the same professional. So having that mandate in or that scope of expertise in helps you to go to another professional and give similar kind of an update on what's going on in her life. I think we talked about it at length. Best letters are personal, non-legalistic, should include copy of identification. Letters from home country should be submitted with a copy of the envelope they came in if possible. And if it is an email, attach an exhibit to the applicant's affidavit explaining that it was received and the context of it.
Lastly, country conditions evidence. I find this to be incredibly important, and the more you can find that will support your claims and your legal submissions, the better. You can check the National Documentation Package at IRB website. They have a lot. Using a different variety of evidence also works. You can use news articles, scholarly articles from peer-reviewed journals. I use them to bolster the arguments. You can make sure that the documents speak to the applicant's personal experiences, and the legal submissions should always work to link the documentary evidence to the client's particular circumstances and experiences.
So some of the other things that because we have been talking about gender-based violence and we briefly touched on human trafficking in Maria's case, but remembering that the forced migration situation, which could be a forced marriage, human trafficking, or forced labor situation, the TRP can be availed for 180 days, which is 6 months period, if the officer who interviews is convinced that she was in a forced human trafficking situation. It doesn't matter whether it was trafficking because of this being a sex worker, or trafficking because of being in forced marriage, or trafficking because being in a forced labor situation. So either of those can qualify for that TRP. When she goes for the interview, the client needs to just have a credibility finding done with this one officer, so she doesn't have to really have it. She doesn't really needs to have gone to the cops and given a statement there. That's not the requirement of IRPA. IRPA only expects this officer to be convinced. If she's gone to the cops and the case is still under investigation, no charges are laid, and you can give the details of the officer to the details of the investigating officer to the immigration officer. Sometimes the immigration officers will just take that information and give the TRP to the clients. TRP usually will not last the whole time. The trial will continue because the trials usually go for very long, as we know. Even after post-Jordan, we still see that the trials all over Canada, criminal trials can take years sometimes. What can happen is that you will apply for a TRP and you'll do renewal of a TRP, and then you'll do another renewal of the TRP, and by that time she would have lived here on a TRP for 2 years, and you can apply for a permanent residency. But
is that a, sorry to interrupt, is that a 6-month TRP that you keep renewing?
Yeah. But
sometimes they give 2 years.
Sometimes they would give 2 years one, but for the human trafficking, they'll usually start with 6 months for sure, and the renewal might be 2 years. But remember, right before landing her, they'll ask you for HNC arguments too. I don't know why they do it. I am not clear why immigration officers just don't land them under the provision that she has been on TRP here for 2 years. They will still ask you to submit some HNC arguments. So if you can actually submit HNC arguments at the time when you are doing just applying for the permanent residency on the basis of that she has been here on TRP for 2 years, it would be beneficial. So keep that in mind. I have gone through the process a few times now, and I feel that the time gets wasted because the officer will write to me and say, can you send me HNC arguments on this file? And I'll be like, but you have her HNC arguments, you know what has been going on all this time, you have been renewing her TRP, but they'll be like, no, still we need this. So it's better to submit that in advance if possible. It never harms. What I'm trying to say is it never harms to put an HNC, even if it is not your application, a standalone application, you're depending on other things, but put in HNC arguments. Live-in care and temporary resident permit, we all know what happens with live-in caregiver program. They lose their employer in between. So if you have those clients, definitely make strong HNC arguments for those files. Temporary resident permits we just talked about, same thing. That's the end of our presentation. This is a poetry. So I write poetry as my healing process of all the trauma work that I do.
And better than the 2 scotches you talked about.
Yes.
That's a better coping mechanism.
Yes, it is. So, and the toolkit that I created with the fellowship money that I received from Law Foundation, there are 2 poems that were included in that particular publication. So this is one of those. I'm not a very good orator of the poetry, but I write, but I'll try to just read it to you. The pain in your voice is your strength. The rage in your heart is your guide. That helplessness you feel is a witness of your care. That hug you extend show you feel. That smile in your disappointment tells me you have not given up. I'm your witness. So what I say is I'm a witness of all the lawyers and all the workers who do this work, and I know it's hard work. So, so gratitude for all the hard work that all of you do. Thank you.
Wow, that was an incredible morning. Thank you so much, Deepa and Yasmin, and thank you to the Barbara Schleifer Commemorative Clinic for your expertise and your compassion and all your patience with us and everything today. So thank you. It was really a real honor to have you guys here, and I hope it won't be the last time. And I think we're all absorbing some of this information, and this will really make us better lawyers and better practitioners, and especially this trauma-informed and client-centered approach. So thank you so much for that.